Good day, Dr. Su. My name is Cindy Linianqi and I'm from Group 4 of T3. My group will be presenting on invalidity of treaties. I'll be discussing on violation of internal law on consequence to conclude treaties and error as a factor of invalidity. A treaty that complies with all the formal procedural aspects may still be unenforceable if it is invalid. So generally speaking, the validity and continuous in force of a treaty and of consent to be bound is presumed by virtue of Article 42 of the Vienna Convention on the Law of Treaties. However, various matters may give rise to issues of invalidity. There are two general grounds of invalidity. The first is relative grounds, the second is absolute grounds. Now I'll be talking about violation of internal law on consequence to conclude treaties. Provisions of internal law regarding competence to conclude treaties are provided under Article 46 of the Vienna Convention. By virtue of this article, a state can invoke violation of internal law only when these three elements are fulfilled. The first is the internal law relates to competence to conclude treaties. Second, it concerns a rule of fundamental importance. And third, the violation is so manifest that the other party or parties must be deemed to have been aware of it. Now I'll be talking about error. Article 48 of the Vienna Convention states that a state may invoke an error as invalidating its consent to a treaty if the error relates to a fact or situation which was assumed by the state to exist at the time of conclusion of treaty and form an essential basis of its consent to be bound by the treaty. However, this article does not apply if the state contributed by its conduct to the error or if the circumstances were such as to put that state on notice of a possible error. This is illustrated in the case of Temple of Prairie Hare. In this case, Cambodia claimed that as a successor to France, it has sovereignty over an area of land which included the Temple of Prairie Hare. One of the key pieces of evidence upon which Cambodia relied on was a map made in 1907 that showed the temple to be in French territory, and that map was sent to the authorities of Siam, which is now Thailand. The court found that the temple was situated in Cambodian territory, and the plea of error made by Thailand has not been made out. That's all from me, and I'll pass the presentation to the next presenter. Thank you.
My name is Tae-Ming Hong. I will be presenting on grounds of invalidity of treaties. The first ground is corruption. If the consent of a state has been obtained through the corruption of its representative by another negotiating state, directly or indirectly, the first state may invoke it as invalidating its consent. The second ground is coercion of a state by the threat or use of force. According to Article 52 of the Vienna Convention, a treaty is void if its conclusion has been obtained by the threat or use of force in violations of the principles of international law embodied in the Charter of the United Nations. The wording of Article 52 clearly refers to the prohibition of the threat or use of force under Article 2, Clause 4 of the Charter. There must, however, be clear and convincing evidence of use of force as pointed out by the International Court of Justice in the Fisheries Jurisdiction case. In this case, the court stated a court cannot consider an accusation of this serious nature on the basis of a vague general charge unfortified by evidence in its support. The history of the negotiations which led up to the 1961 exchange of notes between UK and Iceland reveals that these instruments were freely negotiated by the interested parties on the basis of perfect equality and freedom of decision on both sides. It seems that a peace treaty would invoke some degree of coercion. Additionally, Article 52 invalidates a treaty when it involves the use of force in violations of principles of the Charter and does not invalidate a treaty which is the result of use of force, which is not in violation of the principles of the Charter. Therefore, a peace treaty would be void if procured by an aggressor state's coercion of a victim. On the other hand, a peace treaty concluded by a defeated aggressor state as a result of military victory by a victorious would-be victim, particularly in the case of lawful collective action against the aggressor, is valid.
A very good day, Dr. Su. My name is Clifford, and my part will be on the conflict with jus cogens and the first criterion of jus cogens. At first, the doctrine of state sovereignty and consensual theory of international law were applying the principle of jus dispositivum, where the international rules were voluntary in the sense that the rules may be altered or amended through the consent of all the states involved in the agreement. However, Western states started to accept the principle of jus cogens, where some principles which forms the norms of international law cannot be set aside. Article 53 of the Vienna Convention provides that a treaty is void when it conflicts with the preemptive norms of general international law. A preemptive norms are norms which are recognized by the international community of states, where the rules of jus cogens are not to be derogated, and modification can only be made by a subsequent norm of general international law having the same character. There are three distinct characteristics of a preemptive norm. The first is that the norm protects the fundamental value of the international community. Second, they are hierarchically superior to other norms and rules of international law. Thirdly, they are internationally applicable and are binding to all states. Next, I will be talking about the first criterion for jus cogens. It must be a norm of general international law, which means that the term general infers that the norm must have universal applicability. The most obvious manifestation of a general international law is the customary international law, in which many jus cogens norms stems from customary international law. Treaty rules, on the other hand, does not amount to general international law that could rise to the status of jus cogens. However, this does not mean that the treaties are irrelevant for the identification of jus cogens. In the North Sea continental shelf case, the court described a treaty embodying a norm of general international law that fulfills the criteria of a jus cogens, which is the law of charter concerning the prohibition of the use of force. Although the basic norm was found in a treaty, the Charter of the United Nations is also a form of general international law, in the form of a customary international law. That's it for me, and I will pass to the next presenter.
My name is Cogen, and I will now talk about the second criterion of jus cogens, recognition and acceptance. Article 53 states that to qualify as a norm of jus cogens, a norm of general international law must also be one that is accepted and recognized by the international community of states as a whole as one from which no derogation is permitted. The requirement is one of acceptance and recognition, but this requirement of acceptance and recognition is made up of two other elements, which are first, the international community of states as a whole, and the second one, it is from which no derogation is permitted. It is the acceptance and recognition of the community of states as a whole that is relevant in the identification of norms of jus cogens. In view of the phrase, the international community of states as a whole, a question can be raised whether the acceptance and recognition of all states is required. The international community of states as a whole is interpreted as a very large majority of states or all states less a very small number of states. Acceptance and recognition by all states is not required. In order for a norm of general international law to acquire the status of jus cogens, it has to be recognized by the international community of states as a whole as having a particular quality, namely that it may not be derogated from. As a matter of fact, Non-derogation is the primary consequence of preemptoriness. That is why jus cogens are described as preemptory norms. Evidence of acceptance and recognition that a norm of general international law is a norm of jus cogens can be reflected in a variety of materials and can take various forms. The following materials may provide evidence of acceptance and recognition, which are treaties, resolutions adopted by international organizations, public statements on behalf of states, official publications, governmental legal opinions, and decisions of the national courts. When drafting Article 53, the Commission decided against including any example of rules of jus cogens in the article. The Commission believed that on the basis of state practice and international adjudication, rules having the character of jus cogens would be gradually establish themselves in due course. After the adoption of the Vienna Convention, many rules have been suggested as candidates for jus cogens. However, at present, only a few pass the test. Last but not least, Article 53 provides that a treaty is void if at the time of its conclusion, it conflicts with a preemptory norm. It clearly means that the treaty is void ab initio. The Vienna Convention appears to prohibit such a severance of a treaty in Article 44, Clause 5, which provides that in cases falling under Articles 51, 52, and 53, no separation of the provisions of the treaty is permitted. That is to say, the entire treaty is tainted with illegality and thus making the whole treaty null and void. That's all from me. Thank you.
My name is Tayu, and I will be presenting on the rules having the character of jus cogens. When drafting Article 53, the Commission decided to not include examples of jus cogens in the article. This is because the Commission is of the opinion that rules which possess the character of jus cogens would be gradually establish themselves in due course through state practice and international adjudication. Some of the jus cogens norms that are generally accepted by the international community of states are: first, the prohibition of the use of force; second, the prohibition of genocide; third, prohibition of piracy and slavery; fourth, prohibition against torture; fifth, the principle of racial non-discrimination; and sixth, the principles of international humanitarian law. Article 53 of the Vienna Convention of the Law of Treaties states that a treaty is void if it conflicts with a preemptory norm at the time of its conclusion. The treaty will be void ab initio in this situation. The issue is whether the conflicting provision can be void, but the remaining provisions are still valid, and this is also known as the severability doctrine. The Vienna Convention seems to prohibit such a severance of a treaty. In Article 45, sub 5, it states that no separation of the provisions of the treaty is allowed for cases that fall under Articles 51, 52, and 53. This means that the entire treaty will be null and void if its provision is in conflict with the jus cogens. The relative grounds, such as the violation of internal law on treaty making, error, or corruption, will invalidate only the consent of a state to be bound by the treaties. The absolute grounds, such as coercion and jus cogens, will make the treaty void ab initio. The legal consequences will be determined by identifying whether the treaty is bilateral or multilateral. For bilateral treaties, the legal effect of establishing a relative ground is the same as that of establishing absolute invalidity. As for the multilateral treaties, establishing an absolute ground will render the treaty void and unenforceable. Thus, establishing a relative ground does not affect the validity of the entire treaty for the other remaining parties. Thank you.